Well, the gun was in the car, and it was because the reason of how I felt after those guys had beat me up with the bottles. I felt then like how I felt that I was scared. I was like,
did the victim have a gun?
I can't say. He didn't display it to me. I didn't see it at that time.
Right.
I couldn't really say.
Okay. So you pull out the gun, you point it at him, and he keeps walking towards you?
Yes. I fired a couple shots actually before he even got too closer.
Yeah. Well, maybe he didn't believe that you would shoot him. Okay. All right. Well, ultimately, you killed the victim, right?
Yes.
On October 20th, 2002, this man killed another man outside of a bar. Now, you see, he claims it was self-defense because just a few days prior, that same man beat him over the head with a bunch of beer bottles. But did he go to the police? Did he even go to the hospital? No. Instead, he goes back to that bar with a loaded gun. Now, his claim always was that it was self-defense. He said he left the gun in the car. He just went to the bar. He was carrying the weapon because he was afraid. He then sees the man who beat him. He gets scared, but he leaves to the car to drive away. The man chases him. He grabs the gun. He even fires warning shots before finally killing him. Now, he takes this all the way to a jury trial. They must have felt some compassion for him because they didn't find him guilty of the most severe charge of first-degree murder. They got him for manslaughter. He was sentenced to 36 years in prison. He got a commutation of that sentence. He got 7 years shaved off just last year, and now here he is, another bite at the apple for the Act 23 169 hearing. And what that means, it was passed just last year, legislation out of the state of Connecticut. If you're under the age of 21, you automatically get a chance at parole. Not the age of 18, but 21. And that's why he is here today. Now, he has not done himself any favors while in prison. Write-ups, a lot of write-ups. Even his public defender who shows up, I think she does not do him any justice either. Anyways, we'll go over the appeal to bring more clarity to this case. We'll also hear from the ADA and the victim's advocate. But for now, let's jump in.
So as previously indicated, it's the Public Act 23-169 hearing. It's being conducted in consideration of the parole application for Rafael Abreu, inmate number 305514. Mr. Abreu is serving a sentence of 30 years flat with no probation to follow for manslaughter in the first degree with a firearm. There is victim input in this case. There is also an offender accountability plan in place that has been reviewed and shows that he has completed alternatives to violence basic and voices. He has also obtained his GED. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range risk for recidivism. Mr. Abreu, this is now your opportunity to express to the board why you believe you should be granted parole. You may begin.
Okay. I believe that, I wish I had the brain that I have today 20 years ago because, my reckless action has caused me this situation. I'm very, very sorry for this unfortunate situation and the reason why we're here today. And I take very serious my life and things that I do and my decisions. I make a lot better decisions today. And that's how I feel today. I feel that, back then my decisions weren't like how I think today. The person that I am today and, grown and more mature. And I wanted to say, I would like to start saying by how deeply sorry I am and, for the death of Mr. Martinez. I want to apologize to victim's family. I pray one day that they can forgive me for the situation. And, I'm very sorry for it. And I accept full responsibility for, everything that I've done, everything that's been going on. Thank you.
All right. Thank you for your statement, sir. This panel has reviewed your case extensively from your police report and court transcripts, your entire record with the Department of Correction, as well as a summary provided by our parole officer, the packet of information provided by Attorney Gatto, and the assessment by Dr. Hall. we're very well versed in your case, sir. We do have some additional questions for you. And when we're done with our questions, we'll ask the Office of Victim Services to provide input from any family members of the victim. And your attorney and the state's attorney will have the opportunity to speak as well. When all is done, we'll deliberate, discuss your case amongst ourselves, and give you our decision here today. Okay?
Thank you. Okay.
All right. Okay, so let's proceed. Abreu, is that how I say your name, sir?
Yes.
Okay, Mr. Abreu. So, I mean, this is just senseless. Horrible tragedy for everyone involved, but obviously a life was lost here. I don't want to retry the case, but I do want to talk to you a little bit about what was going on. So there was a prior dispute, right, where you were jumped. Why? Can you tell us why?
There was a guy when we was at the bar that he was hitting on my boy's girl that was with me, that we was there together.
Okay, so that's how you got involved in the dispute prior?
Yes.
And this was like, what was it, like a week prior?
2 weeks roughly. About two.
Okay, about 2 weeks prior. So then you go back out and you go to the bar and you bring a gun to the bar. Why?
Well, the gun was in the car, and it was because the reason of how I felt after those guys had beat me up with the bottles, I felt then like how I felt that I was scared. I was like, and because of how I knew because usually when the people that I used to hang out with out there, in the areas that I was, it was a little bit rough, and I felt like I was somewhat in danger.
Okay, why go out if you think you're in danger? And you have to bring a gun out with you.
My boy, he came to get me at the house or whatever, and I thought, I was like, if he's here, and I didn't want to make him waste his time at that time, and I went out with him. Somewhat, I could say that I felt like it was a little bit of pressure of like going out with him.
Okay. So, all right. Okay. Peer pressure. So you left the gun in the car, and then you see that they're there, the victim and friends.
Yes.
So the prior dispute, was it the victim who hit you with the bottle?
Yeah. Yep.
He himself, not one of his friends.
Well, it was more than one person though.
Right.
It was him and others. Yeah.
Okay. Was there a police report filed from that prior incident?
No, there was not. I don't think there was.
Why didn't you call the police? You were assaulted.
Because I went home, and then the stigma of back then, I'm not sure about now, that if you tell on people and stuff like that, that gets you more in trouble and more danger. And I felt that if I was to do that, how the code of, they say, oh, he's a snitch and stuff like that, and I don't want to put myself where my name is going to be like that, and it make the situation worse.
Yeah. Okay. All right. So you see that they're there, and you go to the car to get the gun.
No, I left. I went to leave,
Right.
and they came after me. They because I went to the car to leave, and then I was waiting on the guy because he's the driver. He was I was with him with Elvis, and then when I turned around, I see that Mr. Martinez was coming or whatever. So now I'm thinking like I really get scared because I'm thinking like I'm going to leave, and you still like bringing the situation onto me, and that's when I went to reach for the gun.
But you couldn't leave.
Because Elvis,
you were not the driver. Okay.
No, I was not yet.
Did the victim have a gun?
I can't say. He didn't display it to me. I didn't see it at that time.
Right.
I can't really say.
Okay. So you pull out the gun, you point it at him, and he keeps walking towards you?
Yes. I fired a couple shots actually before he even got too closer.
Yeah. Yeah. Well, maybe he didn't believe that you would shoot him. Okay. All right. Well, ultimately, you killed the victim, right?
Yes.
And then you went to jury trial. Why'd you go to trial?
The offer wasn't something that, I didn't
What
feel
was the
that
offer?
it was 50 years.
50 years, okay. For murder, and then you were convicted of manslaughter first at 38 years.
Yes,
Last year, you got a sentence modification that reduced it by 8 years to 30 years, right?
yes.
What was the basis of your sentence modification?
My, almost like how we're here today, my behavior and length of sentence and everything that's been going on around, like the COVID and numerous things that were playing out during my incarceration.
The behavior.
Well, no, not so much behavior, but like meaning like, that I've been doing better, that I've been trying to better myself and stuff like that. And
I mean, I would understand length of sentence. Behavior, I could certainly not understand, or maybe COVID, although COVID's over. I mean, it's part of our everyday life. Okay. All right. But in any event, you 8 years to take it off. So now you're down to 30 years. And initially you told our officer you didn't think your sentence was fair. What were you thinking when you made that statement?
so I'm glad you asked me because I was interacting with Miss Wengersman, in like how we're talking right now, and then she asked me that, but it was like a blank of like meaning I wasn't thinking, we wasn't talking directly how I would think, like, because I wrote her request after that. I don't know if she
I
submitted
know.
it.
Yeah, we saw it.
And I told her because at that point she asked me, you think your sentence was fair, and I'm thinking that we're talking like in general because of this, like I've been in prison a little while and I've seen the sentences some guys get and stuff like that. And
You were comparing your sentence to other people with manslaughter convictions?
Yeah, when actual even with murder or stuff like that.
Well, murder less than 30 years?
Yeah,
I
I've seen some
don't know
guys.
about that.
I have seen some guys, with 25 and 30 years. Well, at that time, I felt like when I had got to 38, I seen guys with less than 38 for me.
Well, she interviewed you after your sentence modification, so you were 30 at the time.
Yes.
Okay.
I still, yes.
All right, but that gives me a little better understanding because you were comparing yourself to other manslaughter cases. All right.
Yes.
But then you recognize that 30 years really is fair for taking someone's life, right?
Yes. It dawned on me as soon as I left her office, and I was thinking, I'm like, well, that's not really me. The person that I am today, this is, there's no sentence that could replace a human life.
Yeah. Well, and on top of that sentence modification, you were earning rec credits, right?
I was. The law had changed a few years back. Something happened with the manslaughter, and they ended up taking it back from me again.
Well, they didn't take all of it. You earned some.
Oh yeah, no, I have an amount. I have yep.
You earned some rec, and did you lose any with all the tickets you got?
Yeah, I did. Like, it's still because it was about a year, and I had only caught like maybe like 5 to 7 tickets after I had earned it.
Okay, so let's talk about your tickets because it's very concerning to me that someone who comes to prison for manslaughter first with a firearm, and wants to do better, right? You want to do better, and you want to go home. You're asking for parole. Why would someone in your situation receive 28 disciplinary reports? And I mean, I listed them all out, but some serious disciplinary reports that would cause concern when we're considering releasing you back out into the community.
Okay. My first 5 years, I'm not gonna lie, it was really rough. Majority, if you really do a background or caught, then through the other years, it's like the most recent one, the last one, I was talking with Miss Wengersman. It was because I didn't have the ID at the door, and the lady thought I had flicked her off, but I was just telling her to please wait a minute or whatever. So sometimes, like, it feels like the atmosphere, it doesn't play. I'm not downplaying the situation, just it doesn't play in our favor a little bit as prisoners and stuff like that. You know what I mean? Not that I'm not accepting responsibility, you know what I'm saying, but I see it as like, if the officer is having a bad day that day, any little opposition with any situation, it's not going to play out all right. You know what I mean? And but I apologize to the lady on that last ticket last year. You know what I mean? It was
well, and I'm not going to go for ticket, but but threatening staff at DOC is certainly concerning. Using drugs in the facility is definitely concerning.
Yes,
Why would you
because
make that choice?
when COVID had came, I was really, it really dawned on me a lot of things. Like some of my friends had died during COVID, and I couldn't see my family, and I felt trapped. I felt like, you know, and some of the guys that were around me, like again, you know, a little bit of the peer pressure, I want to say, that were like drinking and stuff like that. You know, I kind of got involved in it. Shouldn't have. I agree. You know what I mean? But I've been clean for 2 years now, and you know, I'm actually happy about that because it opened my eyes to see that, you know, that's not the person that I am. I don't like that. I don't like to live like that.
So what's your sober date?
2 years.
I'm going to need a date because it hasn't been 2 years since you refused to give them a specimen last.
Oh, that day I was telling Ms. Weatherly it's because I suffer from low iron and stuff like that. So if when I'm tired, because I guess low iron causes me to be really, really tired at times. And so that day, that was actually like 2 years ago. Actually, that particular day,
It wasn't. It was a year and a half.
a year and a half, yeah. And
Yeah.
so you know, they were searching the cell and stuff like that, and I felt like, you know, it was one of the moments where and I was tired though. I was actually having one of them situations where I was feeling tired or whatever. So long story short, they ended up taking me to psych or whatever because he thought that I was intoxicated and stuff like that. And you know, it played out bad because I was my mood swing at that time because of how I was feeling about my medical situation, you know, and that's what happened with that situation.
Why didn't you just give a urine sample?
Once I got to SEG, I just wanted to lay down. I'm like, I lay down and, you know, I didn't look at the door no more and stuff like that. I was just, you know,
But do you know what it means to a parole board when we hear that you're refusing to give up a urine sample? Do you know what that means to us? That you're using.
Using, yes.
Yeah.
I understand. Yes.
Common sense. That's our
Yes.
logic. All right. You got your GED. Congratulations on your GED.
Thank you.
You really haven't taken many programs. Why not?
In the past few years, it's been difficult a little bit. I'm on the list right now. I've been waiting to go to this new one that they just signed up. It's been difficult because of DOC, you know, and they have a lot of guys in this prison or wherever. So I try to go to the council all the time, and you know, ever since I facilitated, and then the last time when I went to SEG or whatever, they took me off the list on certain things. So like I said, there's so many guys that are already on the list waiting and stuff like that. So I've been waiting.
Understand, but you've been in multiple facilities where they offer programs.
I've been here in the past 8 years though.
I can see that. But you were also in Cheshire, you were in Garner. I mean, all of the facilities offer different programs. It's just surprising that you've only taken one program in 22 years.
No, I have more than one. There's a few.
Okay, what did you take? Tell us.
I took the alternative to violence.
Yeah.
Voices.
Voices. It was in your cell. You didn't go to a group. Okay.
Yeah. And,
what else?
There was a few other that I had put on there. And plus, I've been having jobs here and there, like in the past few years too. I had a server job.
Okay.
And those are the ones that I can remember for right now.
Yeah. Well, I mean, we have your records.
The AVP,
Yeah, you mentioned that already. Alternative to violence.
Oh, and then my religious service. My religious service that I was going to the church here, and the chaplain's discussion, and a few other ones that I when I go to those church services, and usually we get certificates through that too. And I facilitated.
I don't know. I don't know that I consider church service a program. It's good for you. That's great, you know. But go ahead.
When I was in Garner, I facilitated for 2 years over there, and after I got my GED. It was more of like the timing of how I, like, you know, once I was doing my schoolwork and stuff like that, and I was getting more involved, and I was like there mentally and stuff. And then, you know,
got your GED 17 years ago.
Yeah, and those were the years where I facilitated a couple years after.
Facilitated what?
The for other kids to get their GED, other guys to get their
Oh,
GED.
I see. You were tutoring?
Tutoring, yes.
Yeah. Okay. Understood. All right, tell us about the jobs that you've held.
I've had the server job, the last job I had here. And
How long did you do that for?
I did that for 4 years.
Wait a minute. Are you doing it now? Are you still working now?
No, right now I haven't. No.
Why?
In the past 2 years, I haven't had a job because I've been waiting on the list. That's what I was
Why were
telling
you
you.
removed from your last job? Was it because of a ticket?
Yeah, because of the ticket.
Right. Yep, those tickets will definitely halt your progress quick.
Yes.
And I see that you were chairman a couple times, right?
Yes, yeah.
All right, we got letters of support from your family members as well. It's a tough one. Really is. And you weren't even from Connecticut, right? You were visiting Connecticut at the time of your offense?
Yes.
Is that right?
Yes. Yep.
Where were you living?
I was living in Alaska.
Yeah.
Anchorage, Alaska.
And how long had you been in Connecticut?
I had been in Connecticut roughly 3 months.
And
3 to 4
when
months.
were you planning to go back to Alaska?
I was leaving that week, actually. I believe I had a plane
Wow.
ticket.
Wow. All right. Okay. Well, thank you for speaking with me. I'm going to see what my colleagues have. Ms. Chance, I'll turn it over to you. Thank you.
So, Mr. Brute, part of what you said is that your substance abuse score is pretty high,
Yes.
and you have not addressed that part.
The score, I'm sorry, I didn't get that last part.
The substance abuse score is a 4.
Oh, the substance abuse. Oh, I was going to AA and like I was telling the lady,
And
Miss
what's that?
Jennifer, that I got removed for the ticket, my last ticket. I was going to AA, and I also facilitated on there too. That's how they call it on there. I was going to, facilitate for other guys at the AA, but for some
When did
reason
you attend AA?
that was about I want to say about 5 years ago, 6 years ago.
For how long?
I went for about a year.
And so you said you used to go, but if you look at your tickets, you understand why you have you had I think you had addiction services.
Yeah, yes, I did, and that was pretty much because I only used to really drink. I never used drugs like that, so that's the one that I was always signing up for.
Yeah, well, the PSI said that you had a serious substance abuse problem.
I smoked weed here and there, but that was pretty much it, though. I wasn't really into drugs like that.
But it named, PCP, ecstasy, heroin, and cocaine. You've never taken any of those?
No, I've never used none of those drugs.
Do you think you have a problem with anger, Mr. Brew? I know you indicated that there were instances when you were angry.
I did. I work on it very, very hard today.
Have you worked on it?
I always, before I react, I always think, and I keep to myself, like in the sense of, how is that gonna bring me to like exactly how I'm in jail and my actions. I gotta always pay attention to what actions are gonna come behind once, that triggers that, because I know it's not gonna be positive. So if it's not positive, I stay away from it.
do you think that taking an anger management program might help you?
Yes, yes, I believe it.
Okay. So do you understand when you say you have certain issues and you're not taking programs to address it, how concerning that can be?
Absolutely, absolutely.
Okay. And you know, it's obvious that you're not able to take the programs that you need because you have all these disciplinary reports.
It's all, I wanted to say that it's all in time too. Like once like the ticket clears within like a year, the programming starts coming back in effect and stuff like that. So that's why I was recently like now waiting. The counselor,
Yeah, but in 2023, you have 4 tickets.
Yeah.
Then in 2022, you have 1. And, you know, the one in 22 and 2017, they were serious tickets. And so I don't know how much time you had to do when you received those 4 in 2023, because they were in the months of July and August. And then you get another ticket in July of 2024. So the tickets are preventing you from completing the programs that you need.
yes, and I wanted to say that the one from the last July, that one was cleared already in like November. So that's why the counselor, he had signed me up like December, I want to say roughly, or January, and that's what I've been waiting on right now. And because of that and the list of guys waiting too, though, that he was telling me, the counselor was telling me.
But the problem, Mr. Brew, is you need to stop getting disciplinary reports so that you can take the programs that you need.
Yes, I agree.
And in your opening comments, you know, you said you wish you had the brains that you have today and you wish you had it 20 years ago. Well, you know, whatever corrections you think your brain needs, it's not done yet. And it's evident by your DRs. Would you agree?
I agree.
Okay. And I just wanted to ask you, when you were a food server, how long did you do that for?
4 years?
4 years?
Yes.
And then you said shower worker. What did you do there?
I used to clean the showers after everybody was done taking a shower in the unit.
And how long did you do that for?
I did that one for about 5 years.
Why don't you have a job now?
I've been waiting. I'm on the list right now with the last ticket cleared in November. So that's what I've been waiting on right now.
Yeah. So here's the issue here, Mr. Brew. I think that you need to do some additional programs. And when I read your relapse prevention plan, it says that you're going to obtain your driver's license.
Yes.
But for someone who has served the amount of time that you have, you need to have a whole slew of other things that you're going to do in preparation for when you go back in the community. And I didn't see a relapse prevention plan that would say how you're going to stay sober.
Well, I've been told that usually when you get on parole, they facilitate stuff like that. They tell you, you know, okay, because I do want to go. I would like to go to the Alcoholics Anonymous and stuff like that, and anything that has to do with that. And they give you a plan and places to go to and stuff like that.
But Mr. Brady, part of what you should be presenting to us today should include the relapse prevention plan and a release plan so that we know whether you're suitable to go back in the community. And so you're asking to make a difficult decision when you haven't addressed all of your needs that you need to address and to show that you're suitable, and you haven't demonstrated that you're suitable today.
I mean, I want to say that because, okay, I understand the ticket things look bad, but, you know, I feel that for me personally, that I've been doing better because none of them has been anything with violent stuff, you know what I mean? And that's really what I work on. Like I was telling you, I like to work on my anger because I know I suffer from that. I got problems with that. And as long as I have that in control, I've been working a lot better. I've walked away from a lot of things that I know that, you know, outcomes could have been really bad, like, you know, my situation. And, you know, that's what I'm happy about.
Right.
And
Your last threatening ticket, was that in July of 2023?
2024.
Okay, so do you agree that you need to do some more work on
Yes.
yourself? Okay.
Yes.
All
Yes,
right.
sir.
Well, thank you for answering my questions and sharing with me.
Thank you, Ms. Chance. Mr. Paul.
Question, ma'am.
Okay, so this time I'm going to ask the Office of Victim Services to facilitate input from the victim's family members. Ms. Vasquez, thank you for joining us.
Thank you, Madam Chair. Good morning, Madam Chair and board members. Had the opportunity to speak with the sister of the victim, and she has asked me to read this letter on her behalf. It reads like this. Good morning, board members. I am writing to you today in opposition for the potential release of Rafael Abreu, who has been incarcerated for the tragic killing of my brother, Carlos Martinez. The pain and loss we have endured as a family are immeasurable, and I firmly believe that releasing this individual would be a disservice to both justice and society. While I acknowledge the legal framework that allows for parole consideration, I would like to highlight the profound and enduring hardship caused by the senseless act of violence that took my brother's life. The crime committed not only stripped me and my family of a beloved member, but it also inflicted an irreversible wound on our community. The court, in its sentencing, took into account the severity of the crime. This was not an isolated incident, but a deliberate and horrific act that has left a lasting scar. In weighing whether an individual should be granted parole, I urge you to consider not only the inmate's behavior while incarcerated, but also the impact of the actions on the victim's family, the broader community, and the principles of justice that parole is designed to uphold. Parole decisions should reflect the balance of rehabilitation, remorse, and the gravity of the crime committed. Mr. Abreu has not only taken away a life, but has caused irreparable damage to the lives of those who loved and depended on Carlos, my brother. The emotional, psychological, and financial toll that on our family has been devastating. We continue to struggle with grief, and the absence of my brother leaves an unfillable void. Furthermore, I implore the board to consider that releasing an individual who has committed such a heinous act before serving the full extent of their sentence undermines the public's trust in the justice system.
Are very foggy for you, Your Honor.
It sends a message that the suffering of victims and their families may not be given the weight it deserves.
I church, and it is where I raised
While
my-
rehabilitation is important, it must be balanced with the need to hold individuals accountable for their actions, particularly in cases where the crime
It's
was
my
as
fault.
severe and irreversible as murder.
I've allowed my son to put a GPS
As
monitor
the
on.
family of the victim, we have borne
Not because we
as the
want-
family of the victim, we have borne the unimaginable weight of this loss, and it is only right that Mr. Abreu serves the full sentence imposed by the court.
But-
I respectfully ask the board to carefully consider the profound consequences of this release, the impact on my family, and the need for justice to be served in its entirety. Thank you for your time and for your consideration at this time. Sincerely, Janita. Thank you, board members. This is all that I have for this case.
Ms. Vasquez, and we thank the victim's sister for providing that statement for us.
There was multiple filings.
If the attorney will be able to make a statement. To begin with, State's Attorney Gary, if you have any comments you'd like to make, you may do so now.
Thank you. Yes, briefly. Good morning again, members of the board. The sentence Mr. Abreu is currently serving is appropriate for the severity of the crime he committed, and he should serve what he has remaining of his sentence. In the interest of time today, I will not state all the facts of the case since the board is already familiar and you already stated the facts, but I will note that Carlos Martinez did lose his life due to the actions of Mr. Abreu. We understand this crime was committed when Mr. Abreu was under the age of 21 and acknowledge the programs and work he has done while incarcerated, but this crime was extremely serious and violent. Mr. Abreu was convicted of manslaughter in the first degree with a firearm by a jury after trial. Although originally sentenced to 38 years, Mr. Abreu received a sentence modification, reducing his sentence by 8 years in July of last year. It took great strength for the victim's family member to provide input to us today. It is clear this crime still has a serious impact on the victim's family, and the state takes the same position as the victim's family. Given the serious nature of the conviction and the impact of these crimes on the victim, the state opposes the early release of Mr. Abreu. Nothing further. Thank you, members of the board.
Not
Thank
caring
you,
about
Attorney.
obligations.
Attorney Gavin, if you have any remarks you'd like to make, you may do so now.
Only prosecutors are assigned.
Thank you. I'd like to thank the board members for taking the time to be present this morning and letting me, along with Mr. Abreu, make a statement. There's no denying that Mr. Abreu created one of the most terrible tragedies and caused so much pain. It's even more tragic to have happened to a 20-year-old young man. As a 20-year-old with an underdeveloped brain, Mr. Abreu lived a life of crime and violence. He was angry, lived a life based on impulses, emotions, and without considering consequences for his actions. Since that horrific time, Mr. Abreu has been forced to face the reality of what he's done. He's taken a couple DOC courses and furthered his education to develop skills that assure nothing like this will ever happen again. He no longer has that mental instability or juvenile mindset. I'll acknowledge that he did receive a substantial sentence modification a few years ago, which was talked about. However, the sentence modification won't help guide him on the outside the way that parole will. He spent more than half of his life behind bars, and he needs the guidance and resources that parole offers to support his transition. It's clear that the statement he made, that he's truly remorseful for his behaviors and has changed. He now thinks before he acts, knows why he's deciding to do something before he commits to actions. As a 43-year-old man, he's matured and learned from his past. He now has goals and wishes the opportunity to be released into society with the stable support from parole and his close family members and friends. He's demonstrated substantial rehabilitation here today and also agrees to continue that journey on the outside. We respectfully request that the board grant parole for Mr. Abreu because he has a lot to offer, whether he remains in Connecticut or is deported. Thank you.
You are trash.
Okay, thank you very much for those statements. Mr. Abreu, at this time, the panel is going to discuss your case. We're going to deliberate, and we will come back to you shortly with our decision, okay?
Thank you.
Okay, so this 23-169 Public Act was created to reconsider juvenile sentences. And we're supposed to consider the diminished culpability of youthful offenders as opposed to adults. One of the main factors that we're tasked with considering as set by the Public Act is whether or not the offender has engaged in substantial rehabilitation. This parole board measures that by looking at programming, education, employment in the facilities, and probably most importantly, behavior, disciplinary reports.
and the supremacy of the.
In this case, we have some serious disciplinary reports, infractions that went on for his entire incarceration. They began when he came in and they ended last year.
Okay, that's all I got.
There has been substantial rehabilitation in this case. I also can't find that there's a reasonable probability that he would remain in the community without breaking the law, which is another factor that we have to consider, according to Public Act 23-169. Because if we can't behave in a secure environment, how can we do that out in the community? I just don't find that. I can appreciate that Mr. Abreu was 20 years old when he committed this horrible offense, and that he's not the same person. He probably has matured some. And I'll give him the credit for the 2 years that he's been clean while incarcerated, but it's just not enough for us in a case like this, given the overall negative impact on the victim's family, and the community as a whole.
All of these things.
So I could not support a grant in this case today of parole. It's just not enough here. Ms. Chance, that noise is so annoying. Is the door closed in that room?
Yes, it is.
On the third.
Okay. Unfortunate. Okay, Ms. Chance, I'm sorry.
Madam Chair, I agree with everything that you have said. I'm concerned about
I'd like to say is
whether Mr. Abreu has been
in the motion
rehabilitated enough that he can go out and remain without committing, and I'm not seeing that here today.
I'm hearing them anyway because the case is already.
When I read the offense, part of what Mr. Abreu said was that he was angry at the time. He has not taken that program. He denied that he had a substance abuse, but when the PSI was done, it identified several substances that Mr. Abreu was participating in while in the community, and he has not addressed that addiction services program.
Thank you very much. Just so that
His behavior in terms of the 28 disciplinary report, the most recent, which was last July.
So I appreciate that, and that's all I have.
Part of the reason why he's not able to continue on his journey of rehabilitation. So for me, I don't find him suitable today to be returned to the community.
That is not true. That is not true.
But denied today.
Okay, thank you. Mr. Paul?
I agree with what you both said.
Okay,
Yes, they can do GPS, Your Honor.
all right. And he did receive 8 years off of his sentence last year and a sentence modification. I'm assuming that's due to the length of sentence. It can't possibly be due to his behavior unless the court wasn't aware of the disciplinary report, which I find hard to believe. So, okay, reasons for denial.
Nature and injury,
Inadequate evidence.
and in that, yeah.
For institutional adjustment.
Yeah. Okay, and we're not interested in a rehear in this case? Okay. All right, in the matter of Rafael Abreu, MA number 305514, I'll make a motion to deny parole for the following reasons: the nature and circumstance of the incident offense, the injury and impact to the victim and the victim's family, poor institutional adjustment as evidenced by the disciplinary reports, and inadequate evidence of offender change. Is there a second? All in favor? Aye. Okay, sir, we couldn't grant you parole today. We hope that you'll continue on your journey, and we wish you the best. Thank you, everyone, for your participation.
What you're saying.
This concludes the public act 23-169 hearing for Rafael Abreu, inmate number 305514, and it is 12:07.
Even stating why you.
Am I?
This is the threshold of my church.
Hearing is concluded now. You can exit the room, okay?
Where's that noise coming from?
I don't know who this person.
The background noise is the other McDougal video room.
Allow people I don't know in there for a reason that is absolutely void of any process. There's been no trial. My son's guilty of nothing. Yet you want me to allow people into my church? Can he tell me right now that David is right in his favor and he loves me like a brother? doing. Unfortunately, Your Honor, if this is where we go, this is where I draw a line and say, it is not happening. No one is coming in my home unless you're gonna sign a search and seizure warrant right now, and I wanna see the affidavit that you have to back it up. And this is where we have a very fundamental problem, is I am not going to allow the state into my church. There's a separation of church and state, First Amendment clause that you can't establish a religion in my home. And the second one that says they can't stop the free exercise of mind. You're taking an awful lot of fundamental giant decisions, which the one we're about to make.
Just get the officer, please.
Remembering there's about 100 Supreme Court precedents.
Can you hear us?
Yes, we can hear you.
Yeah, can you please get the officer that's out there?
Yes.
Thank you.
They need you.
Yes, ma'am.
Where
Is the officer there?
Yes.
Okay, sorry, we can't see. It's only fixated on one person. I imagine there's another hearing taking place in a room like right next door from where we are.
Yeah.
So unfortunately, we are hearing every single thing that is being said in the other room.
I just thought that I would leave that ending for you. I don't know. Just listening to the yelling in the background and seeing the man slowly walk out, it all just felt like I should just keep it in there in the moment. And I threw in the cat just, I don't know. That's the cat that I throw in sometimes. Let me know if you don't think it's appropriate. And the reason that I even am hesitant is the hearing after this, who we just saw, the man with his attorney, the crime that he committed was also senseless. But unlike this case, we hear from the boy who was just 5 years old when he lost his father. We hear from his daughter who was 10 months old. She never knew her father. And we hear from the widow who has never recovered from the loss of her husband. That's this case of the man and attorney that just walked in. And I'll leave a link to that hearing if you want to listen to it. It hits very differently. It hit close to home for me personally. Now, this particular hearing, just felt almost like a mockery of the system. And I have to say, what really made it feel that way for me was his attorney. She doesn't show up in person, which I don't know why. She claims to not know how to get her face on the video. And I'm sorry, it's 2025. There is no excuse for that. So she just calls in and then she reads from a script that makes absolutely no sense. And if I was him, I would just be pissed. Like, don't go through the motions if you're not, like, you're just going to be an empty suit. And I'll and I know she had nothing to work with, but that doesn't mean that you just completely throw in the bag. I mean, one of the things she said was, he has taken, these are the words to quote her, he has taken a couple courses to ensure this will never happen again.
He's taken a couple DOC courses and furthered his education to develop skills that assure nothing like this will ever happen again.
How do you put those words into writing as a statement? You are an attorney. You are trying to, how can you even put those words into a statement? These are not words that even an element, he has taken courses to make sure this will never happen again. Oh, make sure he never shoots someone, in a bar fight again. Okay. He now thinks before he acts, which was also a ridiculous thing to say. He literally had just had write-ups a year ago. If anything, you might, you put up some subs, try to do substance. Say his last write-up was here. Since then, he has done nothing. He is working towards there are things that you can say that don't call everybody who just saw the same hearing a bunch of morons. And the parole board, they didn't give him they didn't give him a rehearing. No, he's just going to have to do his full term. They were so disgusted by how he's handled this, and his full term date is 2031. So he's got another 6 years. But we've seen with other cases, they'll give a 3-year window to say, okay, you can come back in 3 years. And this is, I think it's so important to see whether you think he should have gotten the long sentence or not, which I after reading the appeal, I do. I think he deserved every year of it. Is that he's done nothing in prison. He's done nothing. I mean, some of the programs he's taken is in his cell. What a joke that they allow you to do that. It's and this is good to compare to people who have put in an effort versus people who haven't put in an effort. And in this case, thank you, Lady Holly, there's I don't really want to go through all the details of it. I could drop the links in the description. I think I'll just kind of give you a synopsis. I'll read some of it to you. So on October 20th, 2002, the defendant Castro and a few others went to the El Dorado Cafe in Waterbury. While having drinks, the defendant recognized one or more persons in the cafe as being part of the group of people who had been at the pool hall days earlier and had beaten him. So he's all upset that he was beaten, right? Thereafter, the defendant exited the cafe. Now, a confrontation subsequently occurred between the defendant and the victim and others. Now, they don't go into the details again, what they spoke about in this hearing. The gun was in the car, so did he run into the car? Did he pull it out? Did he fire those warning shots? They don't address that in here. The defendant shot the victim and the victim died. They just say it like that. The defendant admitted shooting the victim and asserted that the shooting had been done in self-defense. The defendant subsequently was arrested. He was charged by information of murder, violation of blah, blah, blah. After a jury trial, the defendant was convicted of the lesser included offenses of manslaughter and the first degree with a firearm. The court sentenced him to 38 years imprisonment. And then he got 8 years knocked off because of the commutation hearing, which I wonder how they even gave him 8 years. Like, we don't have that commutation hearing on record, but like he must have had just as bad of a hearing, and they still gave him 8 years off, which just shows that they take these commutation hearings quite strangely. And we have seen them give the worst of the worst years off for their commutation hearing, and we just don't understand it. It's just something Connecticut wants to do. And then we have seen those same people come back for parole hearings, like in this case, and they just get outright denied. So again, it shows you kind of like agendas that I think the DOC has in Connecticut, which is to decrease their population, blah, blah, blah. So let's go. So at trial, the defendant testified that the pool hall fight did not the pool hall fight. So there was a claim that the pool hall fight was about a hat, something stupid like a hat. But he was saying that it was more about like narcotics dealing, and that the guy who he killed was a narcotics dealer and a bad guy. So at trial, the defendant testified that the pool hall fight did not concern a baseball cap. He also testified that the victim had participated in the fight and had struck him in the head with a beer bottle. He further testified that he had not sought medical attention following the pool hall fight because Castro had told him that he and his family would be in danger if the people who had attacked him at the pool hall, if the police became involved. And this is just a dumb excuse because you can go to the hospital if you're seriously injured and not involve the police. Specifically, the defendant testified that on October 20th, 2002, he was in fear of the victim, who had a reputation in the community as being a dangerous and violent person. Additionally, the defendant testified that as a result of his fear, he had purchased a handgun for protection. The defendant claims that the excluded evidence, and this is all a really dumb excuse, right? This is clear lying because remember, it said here he was from Alaska. He had a flight to go back to Alaska. All he had to do was hang low and go back to Alaska. Next is that it's like you're really. It seems like his ego is hurt. He's probably in a bar fight. He probably was hit over the head with the beer bottle. He probably had his tail between his leg and he bought a gun and then went to kill him. That would be my guess. And it seems that the jury, though, found him guilty of a lesser charge. They weren't sure. They think maybe he bought the gun and he went to the bar. He didn't bring the gun into the bar. The guy came to him. If he did fire the warning shots, maybe he just wanted to scare him. And then, and that's why he got the lesser charge. But the judge still gave him a long sentence. So, and this stuff's important because, frankly, we're sick and tired of people bringing a gun to fistfights. Okay, it's like crimes like this that it just balloons, and you hear about it every single day. And it's like, just don't be a you want to fight, you want to be a tough guy, so then bring your fists. Okay, it's enough with this gun violence. You're not a big man because you brought a gun to a fist fight. You're a coward. The defendant claims that the excluded evidence was relevant to the state of mind at the time of the shooting. The defendant argues that he proffered testimony that the victim was a narcotics dealer, and the narcotics dealer are often armed with constitutes evidence of victim's propensity for violence and is relevant to his state of mind. And by the way, the victim did not have a criminal. He had no felonies on his jacket. He had no offenses in the state. He was wanted in other states, but not convicted. So not obviously not the poster child for and he probably was, I imagine that he wasn't a good guy, but the reason that the judge didn't allow the jury to hear a lot of this testimony, and a lot of that had to do with the fact that he wasn't a convicted felon. The unsubstantiated allegation of the defendant regarding the stature of the victim as a narcotics dealer without more was not probative in the victim's propensity for violence. Such conviction may be relevant if the victim's violent character and therefore the defendant's claim of self-defense, depending upon the specific facts and circumstances. So basically, he's in his appeal saying how he's appealing that the judge did not allow this to be evidence because he testified on his own behalf and he wanted to state certain things that the judge wouldn't allow him to do it. Here, the victim's narcotics dealing activities were closely linked to the victim's alleged violent conduct and use of firearms, and to the co-defendant's alleged fear of the victim, and the victim's recent conviction for possession of narcotics with intent to sell had direct bearing on the defendant's claim. The victim's recent conviction for possession of narcotics. I thought I just read that he wasn't a convicted felon. Now I'm confused. Maybe it's a different state. To sell a direct bearing on the defendant's claim that the victim was a violent narcotics dealer and the defendant has shot and killed in self-defense. In this case, the victim's alleged involvement in narcotics activity was not based on criminal conviction, but solely on unsubstantiated. Oh, sorry. They're citing a different case as a reference. So he was not convicted. They're citing a different case. And they're saying, no, in this case, it's not on a conviction, but solely on unsubstantiated allegations by the defendant. Okay. So I was right. And that's right. You can't do that. you can't. He's a dealer. If you're not convicted, that's not going to work as defense. Narcotics dealer accredited would not have allowed the jury to find at the time that the defendant killed the victim, it was reasonable for him to believe that the victim was about to use deadly physical force or to inflict great bodily harm, and it was necessary to kill the victim to prevent such conduct. Furthermore, in this case, no evidence was adduced or proffered that the victim was armed when the defendant shot him, or even if the defendant had even seen or known the victim to be in possession of a firearm. There was no evidence that the narcotics activity played a role in the night of the victim was shot. Consequently, the excluded evidence was not relevant, and the defendant contends to put the shooting in proper context. And they go through B, and they go through C, and they go through blah. But no, he had no case. He's probably lucky that the jury even gave him the lesser charge, saying, we don't know, so we'll. But the bottom line is, you get beaten up. Yeah, that sucks for you. Don't return with the gun. You return with the gun. And yeah, maybe, I'm sure he even said something to instigate it because he knew he had a gun. He thought he was going to be a tough guy. It's no, just go back to Alaska. You would have been, who knows. But I think it just shows, it paints a picture of a criminal mind. And he's probably been walking around telling people his whole life, I was defending myself.
While I acknowledge the legal framework that allows for parole consideration, I would like to highlight the profound and enduring hardship caused by the senseless act of violence that took my brother's life. The crime committed not only stripped me and my family of a beloved member, but it also inflicted an irreversible wound on our community. The court, in its sentencing, took into account the severity of the crime. This was not an isolated incident, but a deliberate and horrific act that has left a lasting scar.